Another key question that we ought to ask in the context of administrative law is about what principles and values should apply in relation to government decisions or actions. Because these principles and values will tell us whether or not decisions or actions made by government are actually wrong or are improper or maybe unlawful. And they become the standards by which we gauge and evaluate government decisions or actions. And there are at least two sets of values that can be invoked in relation to looking at administrative law. And one of them are considered public law values, the other one would be administrative law values in general. Speaking of public law values, one of the key principles there would be the rule of law. And this tells us that even government or even government officials must be subject to the law. So it is not just going to be the governed or the citizens who must obey the law. Even government officials themselves, even government leaders and functionaries must themselves be subject to the rule of law. They cannot be above the law, they cannot disobey the law, but they themselves must comply with the law just like everybody else in society. A second aspect of a public law value concerns the safeguarding of individual rights. And this tells us that the moment a citizen or a party is able to clearly show that he has certain rights in a certain area, then he has an expectation that government must actually safeguard and protect those rights even when it makes decisions or undertakes certain action. In other words, an object of administrative law is to protect and safeguard the rights of individuals, persons, and corporations. And in the event that these rights are violated by executive government decisions or actions, then they have a recourse to administrative law. Another public law value is the matter of accountability. That in the end, when government makes a decision or does a particular act, ultimately they have to be accountable for what they do or what they decide. And accountability, therefore, is not limited only to the context of having an election where people are able to elect their representatives. It means that every decision, or most decisions of the executive government, are actually subject to an issue of accountability. And there must also be consistency and certainty in the administration of legislation. So it's not permissible that two persons who may be in exactly the same position or having the same rights are dealt with differently by executive authority. And it also suggests that there must be certainty in the way that legislation is administered, in the sense that individuals and citizens or corporations know how government will likely act in relation to a specific instance or in relation to the rights of individuals. The other aspect of administrative law would relate to such values as fairness, lawfulness, rationality, openness, and efficiency. The principle of fairness means that when government makes a decision or acts in a particular manner, it cannot be biased against a specific individual or a party, and that it must apply standards which are equally applicable to all. It also tells us that the acts and decisions of government must be according to law. And so therefore we have an objective standard of how decisions are meant to be made or how conduct is meant to be done. The issue of rationality tells us that if there is an occasion or an opportunity for government to provide a reason for its decisions, then there must be a possibility for the citizens who are affected by such a decision or action to know what the decisions are. It means, therefore, that decisions must not only be based on reason, but as much as possible, there should be little room for emotions to come in as far as decisions are concerned. There must also be the element of openness or transparency, so people know how decisions were arrived at, or people know for what reason government acted in a specific manner. And there's always the idea that there must be efficiency in place, because otherwise government will be burdened if every single decision or action, for example, will be subject to continuous questions or continuous reviews. So there has to be a balance between ensuring that government actions are decisions, for example, safeguard and protect the rights of individuals, and yet there must also be room that government is able to function in a way that is efficient and is not subject to a lot of difficulties in the way that they undertake their decision making or the way that they act. And if you go by the book of Craig and Macmillan, there is another way by which we can actually look at the principles and values of administrative law. And they look at it from the viewpoint of administrative justice, executive accountability, and good administration. And as pointed out earlier, administrative justice just looks at ensuring that the rights and interests of individuals are properly safeguarded in relation to administrative decision making and action. In terms of executive accountability, it tells us that in proper circumstances, the executive powers of the state can be called to explain and justify in the way that they have gone about the task. So it is not possible for the executive government to say that whatever actions or decisions they make are not capable or susceptible to being questioned by the citizens or by people whose rights are affected. There is the notion of executive accountability so that government can be taken to task for whatever decisions or actions that they make. There's also the element of good administration, which tells us that there must be executive standards such as rationality, fairness, consistency, and transparency, which I discussed earlier.